Aloha mai kako. This is the October 9th, 2024 Land Use Commission meeting. This is an in-person meeting, which is physically located at Airport Conference Center in Hawaiian Airlines Terminal Building, 400 Rogers Boulevard at the 7th floor, Suite 700, room number 3, Honolulu, Hawaii, 96819. And this meeting is open to the public. Court reporting transcriptions are being done from this Zoom recording. All meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into your microphone. And before speaking each time, please state your name and identify yourself for the record. This is an in-person meeting. Please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting, which will be posted to YouTube and used for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. And if you do not wish to be part of the public record, you should exit the meeting now. I'll also share with all participants and attendees that we will be taking breaks from time to time, nominally 5 minutes every hour, and if necessary, and the meeting continues through the lunch period, we'll take a longer break for lunch. We currently have 9 seated commissioners, and all of them are here today. Along with me are Commissioner Michael Yamane from Kauai, Commissioner Kamakea Ohelo, Commissioner Kahele, Commissioner Brian Lee from the island of Oʻahu. Commissioner Nancy Carr Smith is from the island of Hawaii. Commissioner Bruce Oʻahu is from the island of Maui. Let me correct myself. 2 commissioners are excused from today's meeting, Commissioner Hayashida and Commissioner Miyasato. Also in attendance are the LUC Executive Officer, Daniel Orendanker, LUC Chief Planner, Scott Derrickson, LUC Staff Planner, Martina Segura, and LUC Chief Clerk, Ariana Kwan. To my right, LUC Attorney General, Melissa Goldman, is in attendance. Again, court reporting transcriptions are being done from the Zoom recording. Our first order of business is the adoption of the September 5th, 2024 minutes. Ms. Kwan, has there been any written testimony submitted on the September 5, 2024 minutes?
No, Mr. Chair.
Has any members of the public signed up to testify on the adoption of minutes?
No, Mr. Chair.
Commissioners, are there any corrections or comments on the minutes?
Chair.
Commissioner Carr Smith.
At the last meeting and at a previous meeting, I had requested that a new item be put on the agenda as staff updates or general information. It can be called whatever the commission decides, but I think it's important that we have an agenda item that can be a placeholder for any kind of updates from the staff or anything else that might fall into that category. So I please ask you if we could make that an agenda item going forward.
Okay, so let me get so that's not relative to the specific minutes.
It is because it's not there.
Oh, because it's not there.
Yeah.
Okay. So would you like to make a motion to amend those minutes to include your recommendation for a standing agenda item for updates of the commission by staff?
If that's how you'd like to handle it, that's fine.
Is that correct?
Yes. So I move that we add an agenda item going forward.
You moved it to amend the minutes to recognize that prior recommendation. Right?
Yes.
Okay, so let me restate it one more time for clarity. So Commissioner Carr Smith is recommending that we amend the minutes from our September 5, 2024 meeting to recognize her suggestion at that meeting that we have a regular standing agenda item at future meetings that would enable the staff to provide updates to commissioners as necessary.
Yes, thank you.
Do I have a second to that motion?
I'll second it.
And it's second by Commissioner Oʻahu. All in favor, I'll just do a voice vote of amending the minutes accordingly with that motion, signify by saying aye. Aye. Any opposed? No. So noted. Okay, with that amendment. Okay, on advice of Attorney General, we're going to go back and do a voice vote of that because it's the first vote of the day. So, Mr. Orendanker, could you do a roll call vote of the motion to amend the minutes?
Thank you, Mr. Chair. The motion is to amend the minutes. I'm sorry, I don't know who seconded the,
Seconded by Commissioner Oʻahu.
Commissioner Carr Smith,
Oh, I'm sorry. You were asking. Aye. Thank you.
Commissioner
Aye.
Commissioner Lee,
Aye.
Commissioner Kahele,
Aye.
Commissioner Kamakeo Hello,
Aye.
Commissioner Yamane,
Aye.
Chair Giovanni.
Aye.
Thank you, Mr. Chair. The vote passes unanimously.
Okay, so now we have a amended minutes for consideration. Do I have a motion? Are there further amendments or do I have a motion to accept the minutes as amended?
I'll make a motion to accept.
So Commissioner Oʻahu makes a motion to accept the minutes of September 5, 2024 as amended by the previous motion. Do I have a second?
Chair, Commissioner Lee, I will second.
Commissioner Lee seconds. Do I get a voice vote on this one? No, so we're going to do a roll call vote on this one as well. Oh, I can't. All right. First, just the first of the day should be a roll call vote. All right. All in favor of adoption of the minutes as amended, signify by saying aye. Aye. Is anyone opposed? The minutes are adopted as amended. Thank you very much. And I will leave it to staff to follow through with the amendment. And I'll leave it to staff to follow through with agendizing at all future meetings of the LUC, a standing agenda item for updates.
Mr. Chair, Dan Ardanker, Executive Officer, we'd like to discuss that with our Attorney General as to whether or not we can have a general agenda item like that without any specifics. I think there may be a sunshine law issue with that.
I think that can happen off of the record between staff and the deputy AG and staff can report back to the commission accordingly.
Okay, so we have a request by the commission to staff to have a standing agenda item on all our future meetings, which would enable the staff to update the commission on relevant matters. However, staff has noted for the record that there may be some concerns in doing such procedurally and wishes to discuss the matter off the record with the Attorney General as such. Is that correct?
That's
And so at our next meeting, you will both report the substance of and consequence of your discussions with the Attorney General.
Well, our next meeting is tomorrow, so I think it's gonna take us a little bit of time to have the discussion.
The next meeting, which has not yet been agendized. How's that?
That's correct.
All right. Okay, are we good? Okay, we're good. You get the reason, you get what we want, and you're gonna see if you can work it out. The next agenda item is the tentative meeting schedule. Mr. Orendaker.
Thank you, Mr. Chair. Tomorrow, we are again here for the Mahi Solar matter. On October 24th, we will be adopting the order for the RK2 Partners matter, which we're hearing today. On November 7th, we will be having the OPSD presentation on, that's at the end of November.
What time, what day?
The OPSD presentation is November 7th.
Could be problem, I won't be here.
Okay, well, we've got a couple of open,
Would that be a Zoom meeting?
yes, it can.
Staff can hold it hybrid and whoever wants to participate in person can and whoever needs to participate online can. We could hold it hybrid.
Okay,
There are currently no meetings scheduled for December. January 23rd, we have scheduled a quarterly update and legislative session update. And February 19th, we will be on Maui for SB 97390. And on
what is that one?
ComDem.
Add, remove IAL.
That's the add remove of the IAL designation. That was supposed to have been done this year, but they did not make their filing on time. On the 20th, we'll be on Maui as well for the A and B Properties Inc. motion and Emmanuel Lutheran status report,
What's that date?
February 20th.
Commissioner, is that it?
Yeah, that's it.
Commissioners, any questions or comments on the tentative agenda calendar? So I have one of note. For the January 23rd legislative update, is that where we will hear staff's recommendations to commission on prospective bills that are being submitted to the next legislature?
Yeah. Yes, that's correct, Mr. Chair.
Okay, thank you. The fourth order of business today is DR 24-77 RK2 Partners LLC, a petition for a declaratory ruling. This agenda item is to consider a petition for declaratory ruling requesting the commission's opinion on whether the land classification can remain within the state land use urban district in perpetuity. At this time, I'd like the parties to identify themselves for the record. Petitioner, please state your name and also introduce who's with you today.
Chair, Commissioners, Terry Lee. Good morning, Commissioners. Terry Lee appearing as counsel for RK2 Partners LLC. To my left is Ernie Martin, my law partner, and to his left is Mike Matsuura, our associate.
Can I ask, are all three gentlemen attorneys?
Yes, all three are attorneys.
Thank you. Okay. Thank you very much, Mr. Lee. Now I'd like to proceed with the statement regarding disclosures and conflicts of interest. So in accordance with HRS section 84-14, commissioners are not allowed to take any official action affecting a business in which they or a member of their family have a financial interest. They must therefore recuse themselves from this matter if there is any benefit, monetary or otherwise, to themselves or members of their family. Also, in accordance with legal ethical standards, commissioners should disclose any relationship, business, social, or otherwise, that they may have with the petitioner or representatives or any other parties to this proceeding that may give rise to an allegation of bias or impropriety. Do any of the commissioners have any conflicts of interest or disclosures to make at this time? Seeing none, we'll proceed, and all commissioners are welcome to continue. As a reminder, this is a declaratory ruling petition, so the procedure will differ slightly from our standard approach. Here's the process we will follow for this agenda item. We will begin by acknowledging any written testimony that has been submitted regarding this matter. Next, I will open the floor to members of the public who wish to provide oral testimony on this matter. Once public testimony is complete, I will call upon representatives from the county and state to provide testimony in their capacity as interested governmental entities, but not as formal parties to the petition. The petitioner will then be called upon to make their presentation. After the petitioner's presentation, the commissioners will have an opportunity to ask questions or provide comments. Then I will reopen the floor to the general public for any new and additional oral testimony on this matter. And then finally, the commission will deliberate on the matter based on the testimony and presentations presented. The commission will then determine what action, if any, will be taken in response to this petition. For the record, please be informed that all relevant records and documents pertaining to this matter can be accessed for review on the LUC website at, and I'll say this twice, https://luc.hawaii.gov/DR24-77. That's https://luc.hawaii.gov/DR24-77.
Mr. Chair.
Commissioner Imani.
Mr. Chair, I'd like to make a motion that we move into an executive session to consult with our AG concerning the commission's powers, duties, immunities, privileges, and liabilities.
So recognized. Do I have a second to that motion?
Chair, second.
Motion to go into executive session has been made by Commissioner Imani and seconded by Commissioner Kamakelo Oʻahu. And I take all in favor of going into executive session signify by saying aye.
Aye.
Any opposed? So moved. So we will go into executive session, which will be the commissioners and the Attorney General only. So we ask you to, hopefully this won't be a long session, and ask you to stand nearby. Thank you. We'll go back on the record. So it is 9:41 and we're back on the record. And let me start by summarizing what we discussed and agreed and understood in executive session. So as you may be familiar, if you've read the staff report for this matter, there was a question about whether or not the commission has authority to even grant such a motion for put something in perpetuity. So we wanted to discuss that with our Attorney General, whether or not we even had that authority or whether there were limits to that authority. So that was part of it. And we'll hear, I'm going to ask the Attorney General to put on the record her position on that, which generally says you'll hear that we don't have the authority. Nonetheless, we would like to, in the interest of full due process, give you an opportunity to present your position and to hear from other interested members of the community and the county and the state on this matter. So we want to hear about it, even though we expect that we understand we don't have the authority, if that's fair. And then there was a second question related, but not specific to the one that's before us today. on the question of substantial commencement of work on this parcel. And that question is, which is a very good question, is we're not able to address that specifically today because it's not agendized as such. But if the party wants to proceed, we would welcome a separate request for a declaratory ruling on that question alone. But we can't take that up today. So, Mr. Lee, is that clear?
Yes, that's very clear.
Thank you very much. So let me turn to Attorney General Goldman and ask her to elaborate on the question of our authority to hear this motion.
On that question, I will just direct everyone's attention to page 11 of the staff report for this item, in which staff noted that they have not identified any specific statutory authority or court ruling or previous practice that would grant the commission that ability to affirm state land use district boundaries in perpetuity, and that also staff believes that petitioner has not shown good cause or provided any legal authority for that.
Okay, so we're still going to go forward with your presentation, and let me welcome you to do that at this time.
Thank you, Chair. First and foremost, I would like to apologize to the commission and staff and other interested
Excuse
parties.
me, I got to do the public testimony first.
Okay.
So please hold. Ms. Kwan, please identify any written testimony that's been put forth on this matter.
We've received 7 written testimonies, all from landowners, state and county.
And they are all posted on our website.
Correct.
Thank you very much. Has any members of the public signed up to testify orally before us today?
Seeing none, Chair.
Thank you. Now, Mr. Lee, please proceed.
Thank you. In my overzealousness in advocating for my client, I overreached in requesting the order to that my client's property would remain urban in perpetuity. It's clear that, and I agree with the Attorney General's office, that this body does not have that authority. It's not provided for by law. Having said that, I do want to address some other issues, sub-issues that have been raised, both in connection with the petition that was filed, as well as some of the testimony that has come in. And so in order to do that, I sort of want to distill the relevant facts, the historical facts. So we have, as everyone knows, this memorandum of understanding dated March 30, 1993. And the parties are the Department of Ag and Halikua Development Corporation, which was at the time the original petitioner in this, seeking the reclassification, and the owner of all of the 500 plus acres. And the memorandum of understanding made it clear that there was an obligation to convey 150 acres to the Department of Agriculture. And it's also clear that there are certain off-site infrastructure improvements that need to be done. No question. And then you have the LEC's order, which imposed what we call Condition 19, that simply states petitioner, being Halikua, shall convey the agricultural park to the state of Hawaii and provide off-site infrastructure to the agricultural park pursuant to the terms of the Memorandum of Understanding dated March 30, 1993. Okay. Again, indisputable facts. Move forward a little bit more in time. As we all know, Halikua ran into all sorts of trouble trying to move forward with this development project. And so, HRT comes along wants to acquire some of the land, including the industrial land that my clients now own. And as part of an agreement, and it's called a stipulation, between the Office of Planning, which is now the Office of Planning and Sustainable Development, and HRT, it states in paragraph 2 of that stipulation that the Office of Planning hereby agrees that should HRT, and I just want to make this point, it's not HRT's obligated to acquire the agricultural park, the 150 acres. It has an option of acquiring it. Okay, so should HRT acquire said 150-acre agricultural park site from the Robinson owners and convey the same to the state of Hawaii, then such conveyance by HRT shall satisfy, and I'm just going to paraphrase, condition 19. At least that portion that obligated Halikua to convey the agricultural park to the Department of Ag. Paragraph 3 of the agreement or stipulation states that as a condition to the conveyance by HRT Limited, the Land Use Commission shall enter an order providing that 1, the HRT lands shall not be reclassified for any use other than the presently designated uses of such HRT lands, unless such reclassification is made at the request of HRT. 2, that Halikua's failure to fulfill any of the terms and conditions of the 1996 LUC order shall have no adverse effect upon the HRT lands. This was a condition to HRT conveying the 150 acres to the Department of Agriculture. And then paragraph 6 of the agreement states that with respect to condition number 19 set forth in the 1996 LEC order, upon conveyance of the 150-acre agricultural park site, as herein set forth, the portion of said condition 19 dealing with the conveyance of the 150-acre agricultural park site to the state of Hawaii shall be deemed to be fully satisfied, provided, however, that the portion of condition number 19 dealing with providing off-site infrastructure shall continue to apply to and encumber lands other than the HRT land. So there has been testimony submitted by OPSD as well as Department of Ag that my client is still bound by those infrastructure obligations, contrary to the stipulation that was entered into. And so what I would like this commission to do is to clarify and to enforce this condition that was provided for in the stipulation. I believe, and Aseko is here and they can testify, that they have made commitments to provide these off-site infrastructure improvements to the ag park. Ohana is here. They've made certain improvements and completed them relating to the non-potable water requirements. And so all I am seeking from this body is to enforce the terms of the stipulation that the state of Hawaii, through its Office of Planning, committed to. Now, what is the repercussions if that is not accomplished? Well, it's clear that HRT was induced into acquiring the 150 acres and conveying it to the Department of Ag based on this stipulation and the understanding that the HRT lands would not be encumbered by the condition 19 obligation to provide those off-site infrastructure improvements to the ag park. And really that ultimately is all I'm seeking for purposes of this petition. As I've stated, we were overzealous in asking for the reclassification to remain urban in perpetuity. Clearly that's not permissible. Further, I acknowledge, that you know, it's a separate issue whether there's substantial commencement of the project for purposes of your ability to use an order to show cause proceeding to declassify the land. That's for a later determination, if the commission ever sought to do that. We would obviously reserve all of our arguments and defenses as to substantial commencement of the project. I think other parties here, you know, would testify that substantial commencement has occurred. And so if this body were to seek a declassification, it couldn't use the order to show cause proceeding. It'd have to go through an entire reclassification process. But again, that's not an issue here. What I'm focused on is just having a determination that my client's industrial lot is not encumbered by the obligation to provide those offsite infrastructure improvements to the ag park. Thank you.
Commissioners, any questions for the petitioner?
Mr. Chair.
Commissioner Yamani?
Hi, thank you, Mr. Lee. Just had one question, I think regarding the stipulation, that's referring to the MOU, is that correct?
No,
No.
no, it's a separate document that, and is actually attached as an exhibit to the filing by the Office of Planning and Sustainable Development. And if you have that in front of you, it's identified as at the bottom as Exhibit 10. But it was dated December 29, 2003. And so that stipulation is what induced HRT to acquire the 150-acre parcel, because Halekua was unable to perform that. It was its obligation to do, but HRT stepped in and said, look, if we satisfy that requirement, then all we're asking in return is that it satisfies the condition 19 requirement for the 150 acres to be transferred to the Department of Ag, and our property, our industrial lot, is not going to be encumbered by the obligation to provide the offsite infrastructure improvements to that park.
Okay, and that stipulation is in what document? Is that in a land use order or is that in a separate document or?
It was filed before the Land Use Commission on December 30 of 2003, so it should be part of its official record.
Okay, and then what is that MOU you were referring to earlier? Between what parties were that?
So the MOU is dated March 30, 1993, and the parties are the Department of Agriculture and Halekua Development.
Okay, would you know if the commission at the time adopted that MOU in its entirety at all?
Yes, because in the commission's order, which is condition 19, it expressly references that MOU.
Okay, thank you.
Commissioners, I don't have any further questions at this time, but I would like to invite public testimony at this time. And I do note that in some of the written testimony that was put forth by certain entities, that the question that you raised was identified. And I would welcome parties, if they're so inclined, to come forth at this time and offer testimony for clarification.
Is anyone interested in testimony?
Sure. While they're discussing what they want to do, can staff please tell us exactly where the stipulation is located?
Thank you, Commissioner Carr Smith, Downward Anchor Executive Officer. It is attached to or OPSD's testimony.
Okay, that's what I thought, but. And so when Mr. Lee was referring to paragraph 2 and 3,
Yeah, I'm hoping OPSD will come forward and offer testimony to clarify.
wondering if that's condition 19 and then paragraph 2 and 3? Or, okay.
Commissioner Carsmith, the reference to condition 19 is at the end of the document. It's paragraph 6 on page 5. And it reads that with respect to condition number 19 set forth in the 1996 LUC order, upon conveyance of the 150-acre agricultural park site as set forth herein, or set forth, the portion of said condition number 19 dealing with the conveyance of the 150-acre agricultural park site to the state of Hawaii shall be deemed to be fully satisfied, provided, however, that the portion of condition number 19 dealing with providing off-site infrastructure shall continue to apply to and encumber lands other than the HRT lands.
Could you restate that last part clearly and loudly?
The condition of the portion of condition 19 dealing with providing off-site infrastructure shall continue to apply to and encumber lands other than the HRT lands.
Mr. Chair, I wanted to make one further legal point, and I want to stress that this is purely lawyer speak, okay? It is nothing that my client has indicated any interest in doing whatsoever. But I would suggest to this body that because the conveyance of the 150 acres was a condition, I mean a condition of the conveyance of the 150 acres to the Department of Agriculture was that the HRT land, the industrial lot, my client's property, would not be subject to those offsite infrastructure improvement requirements. A failure of that condition draws into question whether that deed is valid, and whether it's revocable. And I don't think that's something my client's interested in pursuing. I don't think the state of Hawaii Department of Ag or this body would want to see that happen, but it is a legal risk.
I'm a non-lawyer, but I think I understand your position. Does OPSD want to offer any testimony?
Chair, we have OPSD coming up for testimony.
Okay. Please identify yourself and I will also swear in, Katya.
Careful, don't break it.
Don't break it.
Hi, good morning. Allison Kato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here is Katia Palaciano from OPSD. And did you want to swear her in now?
Ms. Balanciano, please state your name and affiliation for the record and I'll swear you.
Katia Balaciano, Office of Planning and Sustainable Development, Land Use Administrator.
You swear the testimony you're about to give today will be the truth?
I do.
Okay, Ms. Kato, please proceed.
Thank you, Chair. Sorry for the delay. We just wanted to clarify a few things, and we understand that the commission is not going to be able to, does not have the authority to act on this petition to approve it or anything, but I just wanted to clarify a couple of things that regarding the stipulation that petitioner mentioned. So the stipulation was, we're not disagreeing with his characterization of the stipulation. That was between OPSD and HRT at the time, their predecessor in interest. But the thing is, OPSD does not have authority to release petitioners from any conditions. So at the time, those conditions all ran with the land, so that it was a requirement that they were obligated as together with Halikua Development Corporation. And, you know, the ag park condition was very important to OPSD support at the time, because these are high quality agricultural lands. So OPSD did request to the LUC the things that were in that stipulation, but the LUC was not obligated to accept that, and they did not. And HRT was present at the hearing on this matter, and they agreed to take out much of that stipulation. And so what eventually came out of the LUC is the 2004 order. So the 2004 order is what stands. And there is no mention of excusing HRT's property from all of the other conditions. In fact, there was a lot of discussion at the hearing as to concern over fulfillment of these other conditions. And we think that the language of the order is clear. It clearly states that the exemption from the OSC was limited to the LUC's order to show cause proceedings, that all other conditions continue to run with the land, and that HRT's lands may be reverted if HRT violates those other conditions. And so based on that, and everything that occurred and the documents that exist, OPSD doesn't believe that there's anything that supports, their interpretation. And just a note about the MOU that was mentioned. So petitioner mentioned the 1993 MOU, and I'm just pointing out that that MOU was restated several times. And I believe the last one was the 5th restatement, which was included in the status report that occurred, the last status report on this on the Halikua Development Corporation matter. So just noting that for clarification. And that's all. Thank you.
Okay, thank you. So let me see if I understand what you said. So I'm going to summarize in lay terms my understanding and ask you to correct me as necessary. So originally the land, 500 plus acres, was owned by somebody else. And there was an obligation or a condition that 150 acres would be given to the Department of Agriculture for Ag Park, along with infrastructure to go with it.
That's correct.
Then that land had one owner, but then it ended up with multiple owners and it was divided up. And this party, RK2, now owns, was it 120 acres or so?
A little more than that, yeah.
Yeah, just more than 120 acres. And with that, was an obligation to convey the 150 acres of ag land. And there was a stipulation that went along with that agreement that the petitioner has put forth, which said that they have to give that 150 acres, but they would be released from the requirement to provide the infrastructure to go along with it. However, even though that was in a stipulation between the party and OPSD, it was never approved by the Land Use Commission. Is that correct?
That's about correct, yes.
About what's not correct.
Oh, I mean, that's simplified version, yes.
Simplified
correct.
version. I didn't say anything incorrect.
No,
Okay. So, as such, since it was not, since that condition removing the infrastructure requirement from the obligation of this particular party was not approved by the LUC at the time, your understanding is that that requirement runs with the land and it's still an obligation of this party.
that's correct.
Thank you. And so you disagree with the petition.
That's correct.
Very good. Commissioners, further questions or comments on this matter? I have an open question whether or not we could even deal with this issue today. Is that something I need to ask you or go into? Yeah, the question. So. Yeah. So my position, and I'm open to others, to listen to others, is that this particular question, which is pretty narrow, was not agendized as such. And if the petitioner wants to pursue it directly, again, I would invite you to petition the commission for a declaratory order on this question. But I'm not sure we could address it today. Yeah, you're looking to amend an order. You basically want to revisit 2004, in which it was put forth to that commission at the time and it was not approved.
Well, I think, and I wasn't there. I don't think any of us were there, frankly. It was over 20 years ago. But as I understand the 2004 order, which was really out of a order to show cause proceeding to declassify the entire 500 plus acres, okay? And so HRT was, the Office of Planning was submitted that stipulation for approval by or as support to for HRT to be excluded from that order to show cause. Okay. So it wasn't about, whether HRT's land continued to be encumbered by the obligation in condition 19 to provide the offsite infrastructure improvement. It was whether HRT was going to be excluded from the scope of the order to show cause because of this stipulation. And so the issue of whether this body was approving the stipulation or not wasn't that issue. It was really evidence of why HRT should be excluded from the order to show cause and what the scope of that order should be. And the stipulation suggested that the order should be beyond just the order to show cause proceeding. And it appears that in the deliberations of this body, they determined that no, we're just going to address it for purposes of this order to show cause. So it has no precedential value going forward. And so the issue that I am presenting to you, and if I need to submit a separate petition for declaratory order, that's fine. I will do so. But I don't think the Land Use Commission back in 2003 or 2004 rejected the terms of the stipulation.
But it didn't approve of it either.
No, it didn't. It simply used that as evidence to exclude HRT from the scope of that order to show cause proceeding.
Understood. Yeah, I think the way forward is for you to proceed with a separate request for a declaratory order on this question. We're not in a position to deal with it today.
I understand.
Chair,
Commissioner Carr-Smith.
I have a general question. Mr. Lee, can you help me understand what may or may not have happened since the status report that you gave us on April 3rd of this year. I'm kind of confused about why this is circling back. Thank you.
Uh, Commissioner Carsmith, I'm glad you raised that question because notwithstanding this tortured history of this project, I think it's fair to say that, the new owners are making, significant progress in going forward. Haseko's, expended a lot of money and effort. Oʻahu has spent, like $100+ million in its PV solar farm. My clients have spent millions of dollars. It's got tentative subdivision approval on the first phase of its industrial project that's going to bring sorely needed industrial warehouse inventory on the market, because I think I hope you know, but I will inform you that that is the most challenging area of commercial real estate in terms of supply. I think the vacancy is somewhere like 1%. Okay, so, this city needs more warehouses. And so my clients are moving very quickly to try to accomplish that. However, they are in ongoing discussions with Haseko because in order for my client to proceed with its development, and I think this is in its most recent annual report, it needs certain infrastructure improvements that Haseko is committed to do, specifically certain road improvements that will provide access to my client's property. And unfortunately, Haseko has, had some challenges and delays in getting there. But, I think we're hopeful, we're optimistic that they're going to be able to meet the timelines that they've recently announced or indicated, so that we can move forward with our project. Now, Haseko's also, committed in the MOU, the fifth amended and restated MOU, to provide those, offsite infrastructure improvements to the ag park. And so, I think, whether it's this morning or at another hearing in my next petition for declaratory order, those are issues that perhaps can be addressed to help inform this commission on how to move forward.
So that's helpful. So is your concern that Haseko may not be able to provide what your client needs, and then that will cause your client to be delayed in their responsibilities? Is that
Yes.
okay? And have there been any other reasons that or things happen that make you be concerned about reversion, and so you're asking for perpetuity, which we can't do? But did something happen? No.
No,
Okay.
again, this is the lawyer in me, right? To the extent I can clothe my client's ownership with more legal protections, then it removes certain risks and uncertainties. So it helps them with their lenders, it helps them with, purchasers of lots or lessees or what have you. The threat of a declassification through an order to show cause proceeding is a substantial one and diminishes the market value of the property and the viability of the development. So to the extent that we can remove that risk, then it obviously benefits not just my client, but, all the other parties.
Thank you.
Mr. Lee, infrastructure means different things to different people. Can you describe in your own words, non-legally, if can, what the offsite infrastructure associated with ag park, what it looks like?
Sure. Yeah. Actually, I can read it from the fifth Fifth Amendment to the amended and restatement of memorandum of
Yeah,
understanding.
please do. I'd like it on the record.
Yes. So it's paragraph E at page 3 of this document, and the title is Haseko to design and construct certain offsite infrastructure to the state agricultural park. Subject to receipt of DOA's approval, which approval shall not be unreasonably withheld, conditioned, or delayed, Haseko shall design and construct the permanent infrastructure improvements for the state agricultural park to include a roadway, potable water, exclusive of the irrigation infrastructure and any associated water commitment, close paren, electrical and communications, and gravity sewer up to the property boundary of the state agricultural park at no cost to the DOA.
Thank you. I mean, I think that further supports the notion that a separate declaratory request for a declaratory ruling on that specific question involving all appropriate parties would be the way to proceed for clarification as opposed to today.
I understand.
Understanding?
Thank you, Chair.
Okay. Commissioners, anything further for petitioner? Okay, we were in public testimony and I will continue in public testimony for OPSD. Did you have anything further to offer at this time?
No, Chair.
Okay, any questions for OPSD from commissioners? Thank you, and thank you for your written testimony as well. Public, Ms. Kwan, anybody else from the public want to testify?
Seeing none, Chair.
Okay, so we will enter into deliberations at this time. It is 10:19. Commissioners, you want a break or shall we go for it? Let's go. So given that the matter in front of the commission is a declaratory ruling pursuant to HAR 1515-100, there are a few ways that the commission can proceed. It can deny the petition, being that the question is speculative, lacks standing, adversely impacts the state commission or officers or employees in any litigation which is pending or expected to arise, or lacks jurisdiction. It can issue a decision on the matters contained in the declaratory order petition, or it can set the hearing before the commission. The commission will now consider the request for declaratory ruling as presented by the petitioner. But let me also note that we have, on advice of the Attorney General, that we don't have the authority, and that has been concurred by the petitioner as well.
Mr. Chair, perhaps to help simplify these proceedings and given how the hearing has gone, I would like to make a motion to withdraw my petition and to make it easier for the commission.
I think it's going to be easy either way.
Yeah,
But
and with, you know, we will prepare a second petition that's more on point.
okay, 1 second. Yeah, I think we'll just proceed with the deliberations, if you don't mind. I appreciate the offer. And I think it's kind of a common sense offer at this point in time, so I appreciate it. But we'll proceed with deliberations and a decision on the motion on the petition that's before us. Commissioners, any discussion? If not, a motion to how to proceed? Mr. Lee?
Yeah, I think I know what the petitioner is trying to get, which is confidence that the property will not revert. And so because we've been advised that we can't do it the way that was proposed, it was discussed that there could be another declaratory ruling proposal. And I'm not sure if we're all on the same page on this, but one suggestion we had was that if that's the confidence that you want, some of the filings today, some of the testimony, but also the fact that substantial commencement would preclude any reversion. Perhaps, I'm not sure if that's what you guys have in mind for your future proposal, but perhaps requesting a declaratory ruling that substantial commencement has taken place would address the concerns of your client. So I just want to, be a little bit more explicit on what we were thinking. Thank you, Chair.
Thank you, commissioners. Yeah, I think there are two parts. That's part one. Part two is whether or not they have an obligation with the infrastructure associated with the ag park. And that might be another separate consideration you put forth before us, but neither of those we can consider today. Simply said, it's just whether or not we can put this into urban in perpetuity, and we think we cannot. So do I have a motion from the commission?
Mr. Chair,
Commissioner Yamani.
first of all, I appreciate the petitioner's position, understanding what you're trying to get at. But based on what is submitted, I'd like to move that this commission deny the petition's request for clarification in its entirety.
Thank you. Do I have a second to that motion? Commissioner Kamakela Ohelo. Was that a second? Yes. The motion was seconded by Commissioner Kamakela Ohelo. Commissioner Imani, I think you already spoke to your motion. Did you want to add anything to that?
No, that was pretty much.
Okay. Kamakela Ohelo, did you want to add anything?
I'll let you, nothing to add.
Thank you. Any other commissioners? Hearing none, the chair concurs with the position of the movant. And Mr. Orndecker, will you take a roll call vote, please?
Thank you, Mr. Chair. The motion is to deny the petition in its entirety. Commissioner Yamane,
Aye.
Commissioner Kamakeo Ohelo,
Aye.
Commissioner Carr Smith,
Aye.
Commissioner Kahele, Commissioner Lee,
Aye.
Commissioner Wu,
Aye.
Commissioners Hayashida and Miyasato are excused. Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Thank you. And we'll look forward to seeing you again, Mr. Lee.
And Chair, just a point of clarification.
Yeah.
Because our petition did address the substantial commencement of the project as an issue, I want a point of clarification that this denial is without prejudice as to raising that issue in our subsequent petition.
That is my understanding as well.
Thank you very much.
With no further business to discuss on today's agenda, I declare this meeting recessed until tomorrow at 9 a.m. Here also at the Airport Conference Center in Hawaiian Airlines Terminal Room number 3. Thank you very much for your time.
Point of clarification, it's not recess, it's adjourned, right?
It says recessed.
It should be at. Okay, but it's a separate issue tomorrow, right?
Separate issue, but it's the same meeting.
Okay, thank
Yeah.
you.
Okay, thank you.